Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzeli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade e-Immigration. If you're working in immigration law, you already know that there's never enough time in the day. That's why the team at e-Immigration has been sharing a ton of helpful resources to make your life a little easier. Head over to their resource center and you'll find on-demand webinars, practical tips for building your 2026 budget, and insights to help your team work smarter, not harder. Whether you're planning for growth or just trying to create a calmer workflow, there's something there for you. Check out eimmigration.com/IRP and start 2026 with more clarity and less stress. Or, of course, click on the special link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. The Immigration Bar, ACLU, and others continue to do amazing work. I want to highlight as many of you as I can. If you're a patron of the show and have a cool recent story to tell, shoot me an email. I know you've got the stories. I know you've got the wins. You're rock stars. This week, the flowers are going to the ACLU and others on the team of NTPSA v. Noam. In that decision, the Ninth Circuit unanimously upheld the district court's decision finding illegal and setting aside the Venezuela vacature and termination decisions and the Haiti partial vacature decision. That is of TPS. The 3-judge decision focuses on jurisdiction and lack of statutory authority for the vacature, but 2 judges provided a concurring opinion which considers the other APA claims and elaborates powerfully on the racist motivations of the decisions. That makes at least 3 courts, by my count, that have found the first Haiti partial vacature unlawful, if you include the district court below in NTPSA. And it includes our win with Brian Cave and others in the Eastern District of New York in the HECA lawsuit. It also makes the Ninth Circuit the first circuit to really tangle with the lawfulness of a full-on vacature akin to that of Venezuela during this Trump 2 era. Our new TPS team, the Miotte lawsuit, is currently duking it out in DC District Court in an effort to prevent the full-on Haiti TPS vacature from taking effect February 3rd. And we expect a ruling before then. Indeed, likely by the time you listen to this. The stakes are high. There are already reports circulating that ICE is preparing for anti-Haitian operations, including but not limited to in Springfield, Ohio, surely for reasons of optics. But again, by the time you hear this, we'll probably know. 4 cases this week, and unfortunately none good for non-citizens. But they're important, I say. And you've already come too far to turn back. So don't. Here we go. Kicking it off with matter of EASO published by the BIA. This case, like matter of shaking my head last week, was actually issued by the BIA and not simply designated precedential by the Attorney General. The case is about discretionary denials and particularly serious crimes. On the latter issue, it holds that matter of NAM is the proper framework to determine whether a conviction is a particularly serious crime for asylum and withholding of removal purposes, which I believed uncontested. Let's get into it. Mr. EASO appears to be a relatively young man from Honduras and applied to adjust to LPR status in immigration court based on the fact that he had an approved special immigrant juvenile visa. Should be pretty straightforward for him then, I believe. In the alternative, he applied for asylum and related relief and protection. All based on some serious childhood trauma from his father and MS-13, if his testimony is to be believed. Except he was convicted in 2022 for 3 counts of sexual abuse of a minor pursuant to Section 22-3010.01 of the District of Columbia Code. Relying on that conviction or convictions, the immigration judge denied adjustment of status as a matter of discretion and denied asylum and related relief based on a finding that the conviction was a particularly serious crime. So that's what's going on. The BIA first tackled adjustment of status. The IJ didn't err in deeming Mr. EASO's testimony about his criminal history not credible, permissibly finding that Mr. EASO was evasive and minimalized his culpability. Not gonna lie, it seems a bit fact-specific, and not many of the facts of the testimony are provided, so that's about all I'll say on that. Generally speaking, however, quote, the respondent's recent criminal conviction and attempts to minimize his culpability before the IJ weigh heavily against favorable exercise of discretion, end quote. Against this, and the serious factual nature of the allegations of conviction, the BIA explains that the IJ properly weighed all positive factors in Mr. EASO's life. That includes, by the way, what removal to Honduras will do to Mr. EASO, so take note, everyone, quote, evidence of hardship to the respondent, if removal occurs, is a relevant favorable factor in a discretionary analysis, end quote. Just unmet sufficiently to outweigh the negatives here to the BIA. On to the particularly serious crime analysis then. This sexual abuse of a minor conviction is, after all, a misdemeanor. Can a misdemeanor be so bad as to categorically preclude someone who otherwise warrants asylum from safety in America? It can, holds the BIA. Matter of NAM is the proper analysis. Pursuant to that case, to determine whether a conviction is particularly serious, an immigration judge, quote, first examines whether the elements of the offense potentially bring the crime into a category of particularly serious crimes, end quote. Only, quote, once the elements of the offense are examined and found to potentially bring the offense within the ambit of a particularly serious crime, all reliable information may be considered in making a particularly serious crime determination, including the conviction records and sentencing information, as well as other information outside the confines of a record of conviction, end quote. And IJ found the elements of the offense to be potentially particularly serious here. Importantly, for example, on this crime, the DC offense requires that the defendant be at least 18 years old and there be at least a 4-year age difference from the victim child, who must be under 16, explains the BIA. Mr. ESO argues that finding this crime particularly serious, though, runs afoul of the 1988 BIA decision matter of Juarez, which I admit I did not know of. Wish I had. Great quote from it, where the 1988 BIA said, quote, except possibly under unusual circumstances not present here, we would not find a single conviction for a misdemeanor offense to be a particularly serious crime, end quote. Well, no harm, no foul for me anymore. To the extent that can be read to create a presumption that single misdemeanors aren't particularly serious crimes, and let's be honest, that certainly seems to be what Juarez is saying, the BIA overrules it. There is no such presumption under immigration law anymore. The 2026 BIA believes matter of Juarez poorly written and isn't here for it. To paraphrase. Also, since 1988, states have gotten quite complicated with their misdemeanor felony dichotomy and label some otherwise serious conduct as misdemeanors. Reasons the BIA, string citing some state crimes. Quote, a presumption that some of these dangerous crimes are not particularly serious runs counter to the particularly serious crime bar's objective of protecting the public, end quote. Now call me naive. I recall a belief from criminal law that it's the criminal justice system that's designed to protect the public, and that the entire point of convicting and imprisoning someone is that once they're freed, the United States does not consider them dangerous and is willing to give them a second chance at life. Don't get me wrong, there can be future consequences based on a completed criminal sentence and conviction, but I've never quite understood why immigration law, and kind of only immigration law, continues to label people dangerous after they dutifully complete their criminal process. But in any event, there is no presumption that a misdemeanor isn't a particularly serious crime, rules the BIA. And don't get the BIA wrong. The misdemeanor might not be a particularly serious crime. You just have to apply the matter of NAM framework. If the elements are such that the conviction can be particularly serious, quote, the sentence imposed is just one consideration, end quote, which kind of brings in the misdemeanor analysis. So actually, the BIA overruled matter of Juarez in its entirety. And having so held, the BIA agrees that this DC offense is a particularly serious one. Even if a misdemeanor, the BIA explains, quote, child sex crimes are particularly egregious, end quote. Indeed, the Department of Justice is taking great pains at the moment to ensure that powerful people implicated in such past crimes are not exposed to the public. To get just a tad conspiratorial. Once deemed to fall within the potential ambit of a particularly serious crime, Mr. EASO had the burden, explains the BIA, to show that the facts and circumstances of his conviction were not of the type as to make it particularly serious. And well, in addition to that credibility problem discussed above, the IJ appropriately found, quote, that the respondent pressured a 15-year-old victim to engage in sexual activity, provided her with marijuana, and caused the victim to contract a sexually transmitted infection, end quote. Not great? Although I would say that that final fact likely has nothing to do with the conviction legally speaking, right? Turning then to Convention Against Torture Deferral, which doesn't have a particularly serious crime bar, the BIA affirmed denial. The theory before the BIA apparently is that Mr. ESO will be, quote, detained upon arrival in Honduras due to his tattoos, criminal history, and deportee status, and tortured while in detention, end quote. But even assuming he will be, the BIA doesn't see a torture claim. It has, after all, rejected similar Salvadoran claims last year, circularly reasons the BIA. Or to be more specific, citing its very recent precedent, quote, absent information regarding the frequency or pervasiveness of the use of torture, the IJ did not clearly err in finding that the country conditions evidence coupled with the factual circumstances of the respondent's claim did not sufficiently establish that it's more likely than not that he personally would suffer harm constituting torture upon return to Honduras, end quote. For all those reasons, the BIA dismissed Mr. ESO's appeal. Appellate Immigration Judge Mullane concurred to hold that the BIA had no cause to overturn matter of Juarez. Quote, the majority's efforts here are a solution in search of a problem, end quote. Appellate I.J. Mullane believes there should be important reasons to overturn past BIA precedent, and the judge doesn't see Juarez as presenting such an issue. Perhaps Appellate I.J. Mullane is also thinking ahead to a day where the BIA composition changes with a future presidential administration, and the 400 decisions they've issued during the Trump II era are potentially at play. Perhaps not. And that is a matter of EASO. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial Advocacy College. Registration is now open. The annual Immigration Court Trial Advocacy College convenes every year in April, only in Kansas City, Missouri, hosted by the Pen and Sword, that awesome community resource founded by Reka and Michael Sharma Crawford. This year, the program has been reimagined and reworked to address the current climate of aggressive deportation enforcement. These times are not ordinary, so the program had to be extraordinary. Expanding from 3 to 4 days, the Trial College provides comprehensive training from beginning to end, real cases taught by real litigators in real courtrooms. the skills you need, the confidence you deserve, and the mentors you look up to, all in one place. Register early to avoid disappointment at www.thepen-and-swordkc.org or at the special links in the show notes. Use special code Immigration Review 26 to get $50 off the Trial Advocacy College this year. That's capital I, capital R. Next is matter of Laurent Castro, published by the BIA as well. The Attorney General decided to make this decision precedential. It used not to be. It's a pro se respondent too. To be honest, he probably doesn't even know that all of this is happening because this is about in absentia removal orders, or lack thereof. BIA starts by noting that as a general rule, it does not entertain interlocutory appeals, but it's taking this one, and quite a few last year if I'm not mistaken, all made by DHS. In this one, Mr. Laurent Castro did not appear for his initial hearing. Instead of ordering him removed in absentia, the IJ continued the hearing to November 2025 and then again to January 2027. The BIA says that was the wrong thing to do. The INA provides that a written notice of hearing, or I suppose a compliant notice to appear, quote, shall be considered sufficient if provided at the most recent address provided, end quote. Use of the word shall, quote, indicates that the requirement that an immigration judge proceed in absentia is mandatory, end quote, to the BIA. So reasons the BIA, the IJ must proceed with this hearing in absentia. Now, pursuant to matter of Tepec Garcia, discussed a few weeks ago, DHS still has the burden to establish that a removal order is warranted. But that's a pretty low burden when the IJ goes in absentia, assuming DHS shows up. Importantly to me, and I guess the BIA here, quote, the notice to appear was mailed to the respondent's last known address, and there is no indication that it was not received, end quote. Because if there was an indication in the Ninth Circuit, I'd argue that the en banc United States v. Rivera-Valdez decision would come into play. Indeed, I'd say this decision hinges on that sentence, at least in the Ninth Circuit. Episode 285, by the way. The BIA also appears to give immigration judges an out from all this, concluding that, quote, the IJ did not set forth any compelling reasons for resetting the matter for a new hearing where DHS had already established removability, end quote. So the BIA sustained DHS's interlocutory appeal. Short decision, because it wasn't initially intended to be precedential. And that is matter of Laurent Castro. Next is Bonilla-Espinoza v. Bondi, published by the 10th Circuit on January 27, 2026. This case about asylum. Pro bono represented at the 10th Circuit too, it appears. Mr. Bonilla-Espinoza came to the United States without authorization and sought asylum in removal proceedings. I'm unsure if he was represented below. It appears he may have only submitted a declaration with his application. Something that I do believe Congress envisioned when they passed the asylum laws all those years ago, but which is very risky to do today. The story is as follows, quote, in 2017, petitioner was charged in El Salvador with associating with illicit groups and detained for the next 9 months without contact with the outside world. He was placed in a cell, or dormitory, with 70 other detainees where he was forced to wear only his underwear and sleep on a metal bed with no mattress, leaving a scar on his hip. Eventually, a Salvadoran judge found him innocent and ordered him released. Petitioner testified that the police and prison guards beat him during his detention, end quote. The 10th Circuit notes, however, that he wasn't very specific about that beating and some other stuff in his immigration court testimony. He was also stopped and beaten by police 8 times between 2018 and 2021, including a bad one that led to him being detained for 6 more days in 2021 because he did not help police root out crime in his neighborhood. Then came El Salvador's somewhat infamous state of exception. As amicus in the Department of State explained, the state of exception, quote, suspended the rights to be informed immediately of the reason for detention, to legal defense during initial investigations, to privacy in conversations and correspondence, and to freedom of association, end quote. Also leads to lots of killings and abuses that the BIA doesn't want to reckon with. Mr. Bonilla-Espinoza was rounded up with 20 other men as part of that in December 2022 and detained for 15 days where he was beaten and diagnosed with ear trauma as a result. Police also forced Mr. Bonilla-Espinoza to exercise nude. On and on, detained again with his family after an anonymous tip that they were all gang-affiliated. After that, he came to the United States. He also testified how his mother always opposed the government in El Salvador and was a member of opposition organizations. Seems to the 10th Circuit, though, that Mr. Bonilla-Espinoza doesn't appear overly involved with it, and that the connection between that and his experience in El Salvador is a bit tenuous. No nexus to a protected ground, said the IJ, who was also frustrated by what the IJ believed was Mr. Bonilla-Espinoza's tendency to avoid answering questions. Other findings, too. The BI affirmed. Seems like Mr. Bonilla-Espinoza was trying to do this pro se and missed his briefing deadline. Counsel came in to try to clean it up at the 10th Circuit, but it was not to be. To be honest, with a missed briefing deadline, he's a bit fortunate he's getting review over much of this. But I, for one, am glad that we're nice to pro ses and pro bono attorneys. The 10th Circuit didn't believe the agency erred on nexus. Maybe there's evidence that police detainments were pretextual and that his mother's political activities had something to do with it. Maybe. He didn't testify specifically enough for the court, meaning the record doesn't compel reversal. As to the IJ's failure to conclude that this was all on account of Mr. Bonilla-Espinoza's membership in the imputed particular social group of imputed gang members, the 10th Circuit isn't sure that counts, and in any event, it didn't believe the argument exhausted before the BIA by pro se Mr. Bonilla-Espinoza. This despite Oil seeming to do Mr. Bonilla-Espinoza a solid and not assert exhaustion before the 10th Circuit. On to Convention Against Torture Protection, then. No nexus showing required there, after all, but the denial was affirmed by the 10th Circuit. It's back to that undetailed nature of Mr. Bonilla-Espinoza's testimony, which the 10th Circuit finds problematic given the high burden required of CAT. Also, the 10th Circuit believes no legal authority cited to show that what happened to Mr. Bonilla-Espinoza constitutes torture, which to recall was being, quote, beaten up on several times, with one assault causing lasting ear damage, forced to wear only his underwear and sleep on a metal bed with no mattress, leaving scars on his hip, and forced to exercise nude, end quote. The 10th Circuit's decision concludes with due process, an argument that the IJ failed to sufficiently develop the record, particularly on political opinion, for this pro se non-citizen. Mr. Bonilla-Espinoza believes more should have been inquired into his anti-corruption and pro-democracy beliefs. Also, he asserted that there was a language barrier that prevented him from testifying better. But to the contrary, explains the 10th Circuit, the IJ, quote, took pains to try to clear up ambiguities and confusion and to elicit all relevant facts, end quote. The court relays some of the IJ's questioning. A sentence to remember for future 10th Circuit cases, but that did not succeed here, quote, this circuit has not explicitly recognized that an IJ has an affirmative duty to develop the record when the applicant is not represented, but even if we were to impose such a duty upon the IJ, we would conclude that she fulfilled it, end quote. That would be in contrast to some circuits, like the 4th Circuit for sure. That is, this affirmative duty to develop the record for pro ses. The IJ did enough, quote, and had no duty to come up with potential arguments for petitioner and then try to elicit information to support them, end quote. On the language thing, Mr. Bonilla-Espinoza didn't identify any prejudicial mistranslations, and again, the IJ followed up often, explains the 10th Circuit. The IJ did enough, and Mr. Bonilla-Espinoza lost his case. And that is Bonilla-Espinoza v. Bondi. Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB-5 support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America. Picture this. It's 10 p.m. on a Friday. You finally sit down to dinner when your phone rings. A panicked client just received a USCIS denial and has no idea what to do. And you answer because that is what immigration lawyers do. The truth is, you don't have to be the one answering every single time. Staffy Live gives you 24/7 bilingual intake specialists who handle those urgent calls with the same empathy, precision, and professionalism that your clients expect from you. And with Staffy Outsourcing, the casework that absorbs your nights and weekends disappears from your plate. Document collection, forms, evidence, packages. They prepare everything. All you do is review and submit to USCIS. I-130s, I-45s, waivers, adjustments, and more than 18 additional immigration case types. Staffy's team handles the workload so you can focus on the legal strategy that only attorneys can provide. Hundreds of immigration attorneys already use Staffy Live and Staffy Outsourcing to reclaim their evenings, their weekends, and their peace of mind without sacrificing client care. And right now, your first 3 cases are free when you get started. Visit staffy.cc or call 786-891-5619 or click on that special link in the show notes. Because you deserve a practice that grows without burning you out. We conclude with Banyee v. Bondi, published by the 8th Circuit on January 29, 2026. This case is about aggravated felony attempted theft. That's INA Section 118A43U, an attempt to commit an INA Section 118A43G aggravated felony. The crime? Robbery under North Dakota Century Code, Section 12.1-22-01. It became a Class B felony because he brandished a gun and menaced others in the course of committing a theft. And this may be, just might be, the first North Dakota crime on the podcast. Insert a Fargo reference. Mr. Banyee is from the Ivory Coast and has been a lawful permanent resident since 2005. If it's an aggravated felony, though, he's removable and ineligible for pretty much all relief. And by the way, DHS doesn't think it's a crime of violence anymore after Bourdain notes the 8th Circuit in a footnote. That's an important decision, that one. Plurality. Mr. Banyee was actually removable for having been convicted of 2 or more CIMTs. He had more convictions than this robbery one, and he applied for LPR cancellation of removal. But you can't get that if you have an aggravated felony conviction. And IJ held that this robbery conviction was not one, not an aggravated felony, and granted LPR cancellation. The BIA had other plans, and on remand, the IJ held that it was an aggravated felony. The BIA affirmed that, and that's the only thing on petition for review. So here we are. And oh mama, here we go. Literally the last thing I need as a crimmigration guy in early 2026. Quote, this court recognizes 2 views of the categorical approach, end quote. What do we got, 8th Circuit? The court explains that under one line of cases, quote, if the state statute allows for fanciful hypotheticals or theoretical possibilities, then the court looks beyond the plain language of the statute, requiring the non-citizen to demonstrate a realistic probability, not a theoretical possibility, that the state would apply its statute to conduct that falls outside the generic definition of a crime, end quote. Yikes. Although it does seem clear to me that the 8th Circuit is saying that by assuming that the non-citizen has the burden because we're talking about relief, that might not be the case even if it's true in the 8th Circuit at the removability stage, but I don't know. It's all weird. That's the first line of cases. Under another line of cases, however, quote, if the statute reaches clear on its face, then the realistic probability is evident from the language of the statute itself, and a non-citizen need not demonstrate any likelihood that the state actually prosecutes cases under hypothetical scenarios that come within the plain language of the statute, end quote. I.e., the realistic probability test has no role to play. To me, those 2 lines of cases appear in direct contradiction. And literally saying nothing more on the subject, or whether both actually apply in the 8th Circuit going forward, the court notes simply that Mr. Banyee invokes the second methodology, because of course he would. And then the 8th Circuit proceeds to analyze the North Dakota statute under that methodology. That is, the methodology that applies everywhere except the 5th Circuit, that the text alone wins the day under the categorical approach. The court believed that the plain text did not win the day for Mr. Banyee. At least not unambiguously so, as it believes required. Let's get into it. First, we need to know the aggravated felony definition of theft. because you can't have attempted theft if you don't have theft. Quote, the generic definition of theft is taking of property or an exercise of control over property without consent, with the criminal intent to deprive the owner of rights and benefits of ownership, even if such deprivation is less than total or permanent. End quote. Emphasis by the court, and quoting the BIA too. The North Dakota robbery statute in turn holds that a person is guilty of robbery if, in the course of committing a theft, he inflicts or attempts to inflict bodily injury upon another or threatens or menaces another with imminent bodily injury. And explains the North Dakota statutes further, quote, an act shall be deemed in the course of committing a theft if it occurs in an attempt to commit theft, whether or not the theft is successfully completed, or an immediate flight from the commission of, or an unsuccessful effort to commit the theft, end quote. All of this means that we need to look to see what North Dakota theft of property criminalizes, going down and down into the North Dakota statutes. Well, in one of its 3 separate parts, that is, of North Dakota theft of property, it criminalizes theft by deception. Remember that, because there are many arguments to go before it becomes relevant again. First, Mr. Banyee argued that North Dakota robbery isn't attempted theft. It's a completed robbery after all, right? The Eighth Circuit explains, though, that if attempted theft is necessarily a lesser included offense of robbery, then Mr. Banyee loses. Quite the holding to me in and of itself. And wouldn't you know it? Theft itself is not a lesser included offense of North Dakota robbery. The Supreme Court of North Dakota has said so. So too, attempted theft shouldn't be a lesser included part of robbery, right? Argues Mr. Banyee. Not so to the Eighth Circuit. Reviewing an important working paper from the early 1970s, that to be fair, the North Dakota Supreme Court also relied on, the Eighth Circuit explains that yes, one can commit a robbery without actually committing a theft because the robbery focus is on the use of force rather than the successful taking of property. But you still have to attempt to take property to successfully rob someone. Kinda counterintuitive that attempted theft is a lesser included part of robbery when theft isn't, but we are talking about the categorical approach. Also, the plain language of the robbery statute itself appears to support this. Moving on then, Mr. Banyee argued that North Dakota theft can be committed with the consent of the victim, albeit the consent obtained through deception. The thing that I talked about a bit ago and told you to remember. Did you remember? And that's a winning argument in other circuits, including the 11th Circuit. And it should be in the 8th Circuit, too. The court just doesn't believe that the robbery statute incorporates this portion of theft, that is, theft by deception. Because how can you try to rob someone by inflicting or attempting to inflict bodily injury, as robbery requires, but also, I guess, at the same time or exclusively, using deception? The 8th Circuit sees it all as ambiguous. That is, that North Dakota robbery incorporates all means of North Dakota theft, and so rejects the premise, given in part that it would negate the purpose of the theft statutes. I'll be candid, I haven't ever seen logic like this, but also, I haven't been around for that long of a time. Mr. Banyee has a final argument. Recall, robbery permits conviction where the perpetrator uses or threatens bodily injury against another, not just the victim. Mr. Banyee argues that because theft can be committed by theft of services, the other can be third parties, I suppose completely unconnected to a robbery victim, and so the statute is overbroad. But as with the deception thing, the 8th Circuit isn't buying that North Dakota robbery incorporates all types of North Dakota theft, and particularly the type that don't make sense in the robbery context. That seems to be the analysis to me anyway. It is a bit confusing. Also, the 8th Circuit does not believe that the North Dakota cases that Mr. Banyee cited actually support his argument. So he did not succeed. In the very last paragraph, the 8th Circuit reminds us that this is actually the Mr. Banyee from the really bad for non-citizens detention case from episode 230. And well, this decision here is no gem for non-citizens either. But that's certainly no way to end an episode. So I leave you with the promise that there are better days to come and better weeks for non-citizens ahead. And that is Banyee v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.